Court does call the case. Peninsula Place versus, is it Trellis Lane? Appearances.
Good afternoon, Your Honor. David Fang here on behalf of the plaintiff.
Sir, your name?
Sorry, Judge. Trellis Lane.
All right. This is the date for non-jury trial, and this is a non-payment of rent case. How much is the plaintiff claim is owing?
Your Honor, the total balance at this time is $3,320.17 plus court costs of $161.
3,000, I'm sorry, 3,000.
$3,320.17.
All right.
Hey, Your Honor,
Sir, of that amount, is there any that you believe that you owe?
All right, buckle up, because this case right here is a textbook example of why sovereign citizen arguments completely fall apart the moment they're exposed to logic, structure, and a judge who actually reads the law. What you're about to see is Trellis Lane, a self-proclaimed natural man, stepping into Judge Simpson's courtroom convinced that magic words, misused legal jargon, and imaginary credit systems can somehow erase months of unpaid rent. This isn't just about money, this is about accountability versus fantasy. Judge Simpson already shut this down once over Zoom, and now we're here in person where reality tends to hit a lot harder. Pay close attention to how every evasive answer creates a deeper hole, how every buzzword replaces actual proof, and how patience slowly turns into precision. Because by the end of this hearing, one thing becomes crystal clear. Courts don't run on vibes, beliefs, or internet law theories, they run on evidence. And today that difference matters.
You were going to say something.
I was going to ask to object what he was about to say as far as about the numbers. About saying what I owe, but you already answered the question. Ask me the question.
And
I
Mr.
can break
Finn,
down that amount if you want me to, Your Honor.
pardon?
I can break down the amount if you'd like me to.
Just one moment, we'll get to that. Sir, can I ask you, I received the documents from you. Is there a reason why you don't think you owe that amount?
Because it's already been paid, Your Honor. Far as reporting adverse information about a co-signer Act 211 of 1989, Peninsula Place is trying to help me liable as the co-signer when I have an interest and a signature and I'm a natural person. So they're trying to go liable.
Okay, so let me ask you this.
Okay.
Just so that I have the background on it. You reside in this unit that's at, I think 315B.
Correct.
At 1000. You reside there.
That's my place of abode.
Well, you live there, right?
Depends what you're talking about. I'm acting as a consumer. So, far as like my, I'm there on special appearance, and my estate stays there. But as far as a natural man, I don't have no place.
And right here is where the sovereign citizen playbook opens to page 1. It's already been paid. Notice how no receipt follows. No bank statement. No dollar amount traceable to reality. Instead, we immediately pivot to word soup, co-signers, reporting numbers, natural persons, and legal-sounding references designed to overwhelm rather than explain. This tactic isn't about clarity, it's about confusion. The hope is that if the explanation sounds complicated enough, someone might just stop asking questions. But Judge Simpson doesn't take the bait. He stays grounded in the simplest, most important fact of landlord-tenant law. Did you live there and did you pay rent in a recognizable form? Everything else is smoke. And when someone needs smoke this early in a case, it's usually because there's no fire underneath.
As far as my estate and my...
Okay, so when whoever is in this courtroom leaves here to go to what they would call home, where does this person that's sitting here go?
To my place of abode, Your Honor.
Which is where?
Peninsula Place.
Okay, at the 315B.
Correct.
All right, that's what I need to know. Okay. do you have a ledger?
And I'll give Mr. Lane a copy also.
Thank you.
And Mr. Fantera, this would be your witness, is
Yes.
that correct? Okay, why don't we do this? Why don't we have her and Mr. Lane sworn in, please?
Thank you.
Yeah, whatever.
Right hand. Swear affirm the testimony you're about to give. Okay.
I do.
Raise your right hand. Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Your Honor, could I give you a real quick context on that?
Yes, please.
We had a previous case last summer where Mr. Lane received Sarah funds. And when we had I have a copy, I have a case number, I have a copy of the unsigned copy of the COD. That was entered on September 9th. SOS paid his rent through September, and it left a small balance of, I think about $119, which we waived. So the balance, even though it doesn't show it on there because we didn't actually get the SOS check till sometime later, his rent at the end of September was $0.
Got it.
So the total balance that's on there is 5 months of rent at $513, water and sewer bills, electric bills. There's not even any late fees. And then there's 161 in court costs. So I just want to clarify that, in fact, none of this goes back past September 30th. In fact, I don't know if you remember, we actually, when we had the previous case, Mr. Lane had sued Peninsula Place seeking the return of all money he paid forever. And he denied that he owed money, but simultaneously applied for Sarah, and he denied he applied for Sarah. You verified with probably Aaron at the time that he had applied for Sarah. He ended up getting Sarah funds. He would not sign the COD, and then you basically gave him a choice. I'll enter the COD, or we'll have a trial and I'll give you a judgment. But it sounds like he's raising some of the same stuff now that he attempted to raise.
Your Honor, free to speak.
Go ahead, sir.
So, Your Honor, when I applied so first I didn't know what I was applying for.
This exchange perfectly exposes the core contradiction of sovereign ideology. Mr. Lane insists he has no residence as a natural man, yet openly admits he lives at the address in question. You can't reject legal identity while enjoying legal protections. Utilities, housing, and occupancy don't materialize out of philosophy. Judge Simpson methodically strips away the performance and locks onto reality. Someone sits in this courtroom, someone sleeps somewhere at night, and that place has an address. Courts don't debate metaphysics. They resolve disputes. And when a defendant tries to redefine existence itself to avoid rent, it usually signals the case is already over. They just don't know it yet.
So when I applied for Sarah funding, I ended up giving my principal information, which was my name, my date of birth, and my social security number. Basically, I'm here today saying that I gave my principal to Peninsula Place and I've never received any consideration.
Your Honor, I don't understand what that means.
This is devastating context for the defense. Not only is this not a one-time misunderstanding, it's a repeat performance. We learn Mr. Lane previously denied owing money while simultaneously applying for rental assistance, a contradiction that alone shatters credibility. You don't apply for help paying something you claim doesn't exist. The court already gave him an opportunity, waived balances, and reset the ledger to $0. And yet here we are again hearing recycled arguments with new packaging. Judges remember patterns. Courts document behavior. When someone keeps relitigating the same fiction, it stops looking like confusion and starts looking like intentional avoidance.
I don't know what that means.
This moment is where legal terminology becomes a liability instead of a shield. Consideration is a basic contract concept, something of value exchanged. Housing is consideration. Shelter is consideration. Access to a residence is consideration. Mr. Lane's claim that he received none is not just wrong. It contradicts the physical reality of him living there. Judge Simpson's reaction isn't frustration, it's restraint. He's watching someone misuse legal language in a way that collapses under its own weight. And this is a critical lesson for viewers. Knowing words isn't the same as understanding law. Courts care about function, not performance.
However, are you Trellis Lane? That's a yes or no. Because I'll tell you, if you are, then we'll go ahead with the trial. If you're not Trellis Lane, then I'm going to give them a judgment by default because Trellis Lane hasn't shown.
I'm here on special appearance.
No, you can't do that. You are not an attorney at law because you can't appear for somebody else. So my question is, and I'll ask it again, are you Trellis Lane?
Yes, Your Honor.
Thank you. So, Mr. Lane, October of 2022, did you pay rent to the landlord?
Yes, Your Honor.
Okay, and how did you pay that?
I'm paying with my credits that's on file. So I sent instructions back in May, basically to get my account zero every month.
You do what?
I sent instructions back in May, then I sent another one to December to the CEO.
The CEO of what?
American Campus Communities. Saying it right. So he's seen my email, so he's aware of what's going on. Basically, like I say, I'm looking for consideration. I have not been getting no consideration, no adequate consideration.
Well, you get adequate consideration for the contract and any payment by virtue of the fact that you have a residence. So I don't think consideration is even an issue.
But yeah, I have several questions.
Well, you can go ahead and ask your questions, but I don't know. Let me just ask this. October 2022, how did you pay your rent?
I paid with my endorsed, took the bill, I endorsed it.
Did you give them cash?
We don't have,
We being whom?
I'm saying it's a credit system, Your Honor.
It's a what?
Credit system. We don't.
So who's in charge of this credit system?
So who's in charge?
Surely.
I mean, we haven't had money since 1933, the Emerson Bacon Act.
We being whom? Who are you talking about when you say we haven't had money? Who is we?
As far as like the United States haven't had money since 19.
Oh, they definitely have, and I spent my share.
Here it is, the sovereign citizen rent payment scheme laid bare. Cutting the bottom off a utility statement, writing pay to the order of, and mailing it in as if it were a check. This isn't payment, it's pretend banking. There's no issuing institution, no backing account, no mechanism to convert it into US dollars. Judge Simpson immediately targets the fatal flaw, access. If money exists, it can be accessed. If credit exists, it has a source. And when asked to identify either, the answer dissolves into abstraction. This is why these schemes always fail in court, because imagination doesn't clear balances.
So, I don't know. You're saying you gave them credit.
Yes.
In what form did you give them credit in the month of October 2022?
Then credit, I took the bill, which they give me a bill every month, which is a statement. I take the statement. If you want, I can show you what I'm doing.
I know what he's referring to. Can I show you?
Yeah.
This is the moment the defense collapses entirely. After layers of jargon, theories, and circular explanations, we arrive at the only question that matters. Did you pay in US dollars or something that accesses them? The answer is no. Everything before this was noise. Judge Simpson's precision here is surgical. He doesn't argue philosophy, he demands proof. And when none exists, there's nowhere left to hide. This exchange demonstrates why courts are immune to pseudo-legal tactics. You can redefine words, invent systems, and deny reality, but you can't fabricate evidence.
Well, show him and then...
I got copies for him. Here's what he's getting, Your Honor. We have a third-party billing company called Zigo. And so what they do is every month they bill the utilities. So he gets this bill, and then you'll see at the bottom, what he writes is pay to the order of Peninsula Place. And so what he's taken, so for example, the top one says pay to the order of Peninsula Place, $662.12. That amount is his monthly rent plus the $123.12 in utilities that are at the top. There's 3 of these that I've attached. So what he does is he cuts off the bottom and he mails that in as with instructions to pay to the order of Peninsula Place as if that's a check.
Have this marked as plaintiff's exhibit and 2. The ledger being 1. But Mr. Lane, you have a copy of what I've marked as plaintiff's exhibit 2. Is what Mr. Fantera described, is that correct? Is that what you do?
Yes, I'm accepting the credits that's given to me and I'm transferring it back.
Who's giving you this credit? They who?
So Peninsula Place, so in the beginning, when I signed up with Peninsula Place, I gave my principal information. So those payments are supposed to come to me as credit. So
what payments?
The payments that's coming every month. So those payments, they're trying to hold me liable for it, and I'm taking the credits that I'm receiving and dishing it back to them, to Peninsula Place.
Who's giving you credit?
You said who's giving me credit?
Yeah.
I have credit, Your Honor. I have a security interest.
In what?
And this so-called contract with Peninsula Place.
Okay, but who's giving you credit? Young man, you keep using these terms, payment, credit, and it seems to me as I'm listening to you that you're using them improperly. So my question is, have you paid anything to the plaintiff in US dollars or anything that evidences US dollars?
No, I haven't paid in US dollars.
Or anything evidencing US dollars? Like a check, credit card, anything like that?
So this is...
No, that's a yes or no.
Can you repeat the question, Your Honor?
Have you, let me just break it apart so we get it real clear. Have you paid for the months of October 2022, November 2022, December 2022, January 2023, or February of 2023? Have you paid to anything to Peninsula Place in US dollars?
No, Your Honor.
Have you paid anything to them that is evidence of an account which holds US dollars?
Yes, Your Honor.
What? And what account is it attached to? You better be careful about answering my question. Because if you're telling me that you gave them or paid them something that evidences an account that can access US dollars, show it to me.
At the end of the day, this case isn't complicated. The judge didn't rule against Mr. Lane because of attitude, belief, or identity. He ruled based on evidence, or more accurately, the complete lack of it. Housing was provided. Rent was not paid in any lawful or accessible form. And no amount of sovereign rhetoric can override that reality. Judge Simpson handled this exactly how courts are meant to, patiently, clearly, and decisively. If you found this case as shocking as we did, hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns. These cases matter, because reality always wins in the end.
You said access to US dollars? Right here.
What is that? What Mr. Fantera just gave?
Yes.
How does that access US dollars?
Because, Your Honor, this account, I'm the holder and I have the interest.
Then show me the balance on that account.
They show you the balance?
Yep.
Just showed you the balance.
No, you haven't shown me anything. Show me the balance on the account. If you give somebody something that evidences that they can access US dollars, then there is a balance on that account in terms of what you're giving them. Much as if somebody gave a check to them, they would be able to show the account for which they can then present that check and receive US dollars. Show me that account, Mr. Lane.
Like I said, Your Honor, I don't know what else you're asking for. This is the,
No, you know exactly what I'm asking for.
you're asking for something that's coming out.
Something that evidences that by that piece of paper that you've given them, that they can access US dollars.
Okay. I don't have any other account besides this, Your Honor.
You don't have any what?
I said I don't have any other evidence besides this right here.
That does not show me that they can access US dollars.
Okay.
Where would they take that to, in your mind? Where would they take that to access the United States dollars?
Put it on the ledger.
Where would they take it to access US dollars?
So, okay. So, Your Honor, so I got a question. As far as landlord and tenant relations, relationships, it's sitting here.
I'll try to answer your question as soon as you answer mine.
Okay.
Where would they take it to access US dollars?
They would take it and take the check and put it on a ledger with my credit. Because if I owe something, Your Honor, it would be in a negative balance. How can I pay something that's in a positive balance? How can
You don't have a positive balance.
this is
You have given them a piece of paper that you yourself just said is a check. So where would they take that to access your account
so, Your Honor,
and receive US dollars?
they're acting in dishonor. They're taking it and they never said anything about or object to it. So it was off.
Oh, they're objecting now, certainly. Where would they take it, Mr. Lane?
So where would they take it? I mean, as far as they have a security deposit deposition bond. So they have it in a financial institution.
What financial institution
I'm not.
would they take it to get cash from your check, as you call it, that would then be debited from your account? Where would they take it?
Debited. So what about the credits, Your Honor?
I don't see a credit.
On this paper, it says credit payments and credits.
That's not what it means, to the extent it says that. You have no credit. Where would they take it to get US dollars?
So where would they take it? They would take it out of my trust, Your Honor.
Out of your trust.
Yes.
Where is this trust located?
We all have a trust in me.
Okay, let's say we all do. I'm not accepting your premise, but let's say we all do. Where is your trust located?
I'm not sure where it's located, Your Honor.